start with breaking news from here in D.C. over at the Supreme Court. Here's the deal. Just in the last couple of minutes, justices are saying they will not hear a major case on transgender rights, declining to hear the case of Gavin Grimm. He's the transgender student who sued his Virginia school to use his gender-appropriate bathroom. Let me bring in NBC News justice correspondent Pete Williams. Pete, this was something on the docket that a lot of folks have been looking for. What does it mean for Gavin Grimm? What does it mean for schools and students more broadly?
Well, it's the end of a long legal road for Gavin Grimm. He originally went to court in 2015 after his freshman year in high school. He announced that he was transgender, that he wanted to use the boys' bathroom. And at first the school said fine, but then the school board, after holding a public hearing, decided no, that he would have to use a separate single-stall bathroom, which he found stigmatizing. So he sued one of the lower courts. It went to the Supreme Court. But then the Trump administration changed an education department policy that the lower courts had relied on and said it was not a violation of federal law for schools to do this. So the Supreme Court decided not to take his case. He refiled it. It went back through the appeals court again, and he won, and then the school board appealed again. So two things have happened since then. One is now the Biden administration says, yes, when schools decline to let a transgender student use the bathroom of their choice, that violates the federal law known as Title IX, which is the one that says schools cannot discriminate on the basis of sex between boys and girls in any of their school programs. And the second thing is that the Biden administration has reemphasized that Obama-era ruling that says this is a Title IX issue. The second thing that changed, of course, is the Supreme Court's ruling last year that the Title VII of the Civil Rights Law, a separate civil rights law, says that employers can't discriminate against transgender on the basis of gender identity. And the Biden administration says that logic applies to Title IX as well. So what it means for Gavin Grimm is a victory. All of the lower courts, all of the federal appeals courts that have looked at this question have come to the same conclusion that it does violate Title IX. So this is not a nationwide precedent, but now there's, I think, 3 courts of appeals, 3 federal circuits where this is the law. And so far, the Supreme Court has turned away any efforts to challenge that.
Pete, very quickly, does this mean anything, the fact that justices are declining to hear this case, for some of the other potential legal challenges related to something we've covered on this show, which is trans athletes looking to play sports at various schools around the country and some of those prohibitions being put in place by states? Or is this a totally separate track, has no bearing?
Yeah, so 2 things I would say. First of all, Justices Clarence Thomas and Samuel Alito said the court should have taken this case, but that's only 2. It takes at least 4 to grant a case. The simple answer to the question is no. Okay. It merely means the court, for whatever reason, isn't taking the case. It's not affirming the Fourth Circuit's ruling here or any of these other appeals courts' ruling that said that this is a Title IX issue. But that is the question in these sports cases, and they're undoubtedly coming to the Supreme Court.
But this morning, Pete Williams with in our Washington newsroom. Pete, thank you.